hope everyone has enjoyed the time of the conference so far. We've had a wonderful start with 2 panels, and we look forward to 4 more wonderful panels as the time goes on. But as wonderful as the panels have been, I think in many ways this is a part I look forward to more than any, is the chance to introduce Judge Posner as our keynote speaker during lunch. He's a longtime member of the faculty of the University of Chicago Law School, an honored judge of the Court of Appeals for the Seventh Circuit, perhaps the most influential legal scholar of our time, authored nearly 50 books. By my count, he probably has more than I'm even aware of. Began as a leading writer of the law and economics movement, has branched out into fields such as law and literature, judicial biography, jurisprudence, and more fields beyond count. But more to the point, I still take pride in the fact, whatever we shall say, his first original scholarship began in antitrust, where all the real action is, and a wonderful place to begin a career. New York Times has called him one of the most important antitrust scholars of the past half-century. The current chairman of the FTC lauds his towering reputation and tremendous knowledge of antitrust. 2 editions of his book on antitrust law remain, several works in the field, starting points for analysis, and more importantly, he began with telecom. As we found out from Roger earlier today, not only was he an assistant to a federal trade commissioner in 1963-65, but he worked on the Johnson-era Rostow task force on communications policy, which oversaw the very genesis of what became the case that eventually broke up AT&T. And without further ado, I shall give you Judge Richard Posner.
Thank you very much, Chris. So I needed a generous introduction because I realized, listening to the very interesting talks this morning, that I actually hadn't thought about telecommunications policy since 1981. So I'm a kind of Rip Van Winkle here, giving my little antiquarian speech. And I was also struck by Mr. Weber's very lucid discussion of the history of telecommunications technology. And I thought he made a very powerful argument for the proposition that everything that's happened has been the result of technological advance, and that the judges and the lawyers and the economists are the corks bobbing on the technological waves. So my comments are antiquated and epiphenomenal. So in the fall of 1967, I left the Solicitor General's office to become the General Counsel of President Johnson's Task Force on Communications Policy. General Counsel was a grand title for me. The entire staff of the Task Force on Communications Policy had about 5 people, so there was 1 other lawyer. And it was under the direction of a young fellow, Alan Novak, who Yale Law School graduate, who was some kind of personal assistant to Eugene Rostow. Rostow was a former dean of the Yale Law School, who was the Undersecretary of State for Political Affairs, and he was the chairman of the task force. And it was noted at the time that the fact that Rostow had been made chairman of this task force was a testament to his unimportance, because you would never give the number 3 person in the State Department such a modest and peripheral task if he weren't a nobody. All I remember of Gene Rostow in that capacity, beautiful office in the State Department, beautiful office, and the best tailored man I have ever met. I mean, this is a memory of 41 years. So he made a big impression with his 3-piece suit, and he was very elegant and lordly. Had nothing to say about telecommunications. Had no interest. And the curious thing about it, so we met with him once, and he made some irrelevant remarks. His favorite word, though, I remember, was démarche. a diplomatic word, a démarche, which I think is just a statement or something. So, and a curious thing, I didn't think about it until today, that somehow this task force, there was no one between Gene Rostow and the staff director, Alan Novak. You'd think there was a task force with members, and then there'd be a staff of young people. But there was just Rostow, and he had no interest. But you know, it was fun. There was a very good economist on our staff who we call the director of research. Only no one to do the research, so he was the researcher. Leland Johnson, very good price theorist from Rand, who'd achieved some academic celebrity with what was called the Avers-Johnson effect on the incentive of price-regulated firms to overinvest because their capital costs were not constrained as effectively as their operating costs. And he was excellent. It was really fun. And our task force had a very, very broad mandate, and much of what we dealt with had nothing to do with the regulation of AT&T. But and it's really funny to think about it after all these years. Cable television was just emerging from its original very limited function of, you know, overcoming topographical obstacles to broadcast transmission. But we had these dreamers who were talking about hundreds of channels, you know, and transformation of American culture. And also, which is truly antiquated, great debates over pay television and whether pay television would erode community in a sense of community in the United States, which depended on free television. And if you actually had prices for television programs, some people would be excluded, and your culture would fragment. Well, that's very old-fashioned. And then there were these companies called record carriers. You probably never heard of record carriers, many of you. But these were obscure companies that handled international telex traffic. And of course, telex, that's another antiquity. But there were a lot of issues about them and about satellites. Communication satellites were just coming into force. But we did talk about AT&T, and we had the founder. I forgot his name. Who's the founder of MCI? I'm sure you. Pardon? McGowan, exactly. Yes. I think it was. Well, name McGowan rings a bell. I think he was the fellow who came and lobbied us, and of course AT&T people and so on. So and we were skeptical about AT&T's monopoly and about regulation in general. Even though the 60s is the great era of, you know, collectivism, socialism, great society, but there was skepticism about the old-fashioned public utility and common carrier regulation, and that had started in the 50s. Economists had begun to question regulation, that kind of regulation, and in the 60s, George Stigler and others were writing critical articles. So there was skepticism about regulation, and it was reinforced when you met the regulators and the people and the people from AT&T regulated. And there was also hostility to monopoly. That was part of the antitrust culture of the 50s and 60s. So now I left to go into teaching in the summer of '68, and I think we had pretty much finished. We, the staff, had finished the report, but then it went into the White House, and I think got diluted in some ways. And then it was issued in December '68. Well, that was the very end of the Johnson administration, and then Nixon came in. I don't know what effect really the report had, but one of the engineer on our staff, Walter Hinchman, became the head of the Common Carrier Bureau at the FCC, and the FCC was beginning to turn against the AT&T, and I think what Weber was saying was very pertinent. There's new technologies had arisen, which facilitated a competition. The obvious examples, the microwave towers, they're much cheaper than, building underground cable and so on. So there were these competitive pressures, and the FCC became responsive. And I also think the AT&T's attitude of never yielding an inch, it irritated people, including the FCC. But, the hush-a-phone was the famous example of that absurdity. And it wasn't. I think it wasn't '68 that the FCC issued the Carterphone decision, which permitted interconnection. It was just acoustical coupling, but nevertheless, that was a portent, and it was mentioned this morning, the above 890 decision earlier. So the logjam was beginning to break in the FCC, and so maybe the report had a bit of an effect. So anyway, but I became interested in telecommunications policy. The first course I taught at Stanford, where I went in '68, was on telecommunications. And I started writing about regulation, and I published in the first issue of Paul McAvoy's Bell Journal on cross-subsidization, other things. Anyway, then the AT&T suit was filed, monopolization suit, and shortly after that I was asked to give a talk in New York, I think mainly to securities analysts, about the case. And I said, it seemed like an awful long shot trying to break up the Bell system because, it was heavily regulated. All of AT&T's services were provided by tariffs that were approved by the FCC. And it seemed unlikely that you could have antitrust come in and disrupt this schedule. Of course, as it turned out, the FCC, which became progressively more hostile to AT&T, was happy to allow the antitrust suit to proceed, and it made sure that it didn't create regulatory obstacles by approving exclusionary tariffs. Well, at the end of my talk, an AT&T lawyer came up to me. I think it was Hal Levy, who was the senior AT&T employed lawyer on the case under the general counsel, Mark Garlinghouse. And he asked me, if it was Hal, asked me if I'd be interested in consulting for AT&T on the case. So I said, sure, why not? Make some money, interested in telecommunications. So that began actually pretty deep involvement for a period of about 4 years. And oddly, I don't really remember a great deal about all this 4 years of consulting. I think the reason for it was that most of my work consisted of attending meetings in New York, and I think I must have done some preparatory writing, but I don't remember any of that. And I think the reason I don't is that the meetings were always the same. They were the same because there were two major law firms involved: Dewey Ballantine and Sidley and Austin, and George Saunders, then a pretty young partner at Sidley, and very, very able person, colorful. He was sort of the principal outside lawyer. So he'd attend these meetings, and I would attend. And there were people like Hal Levy, and also AT&T formed something called Administration D, which was a gigantic in-house paralegal operation. It was huge with engineers and all sorts of functionaries. The reason the meetings were so repetitious, and that's why they're kind of a blur, it was captured in joking comment that George Saunders used to make to me. So here was Will Baumol. This was the principal economic advisor of AT&T on the case, very distinguished economist, then from Princeton, very articulate. And what George said, what George used to say to me was, Baumol has made a great deal of money by telling AT&T that 2 plus 2 is 4. If you take away 2, you're back to 2. If you add 1, you've got 3. If you double it, you've got 6. So what he meant was that Baumol and I and George, others, we would explain in these meetings over and over again the very most basic elements of, regulatory economics, economies of scale, and so on. And the audience, the administration D people, AT&T engineers, were extremely unreceptive. They didn't like this stuff. They didn't understand it. It had to be repeated to them constantly. Now, one thing that struck me in these meetings very early on was that AT&T did not correspond to my impression of a private company. It reminded me of the government. I'd been in the government for several years. It was very bureaucratic. There didn't seem to be any interest in customers, for example, competition. There was an interest in not competing. That was certainly clear. But there wasn't. There didn't seem to be any entrepreneurial spirit. I didn't know much about private companies, but I just had a feeling this is not what I expected in the private sector. Very shabby quarters, for example. I think they didn't want to appear to be opulent. So their position, of course, was that nobody should be permitted to interconnect with the network except GT&E and another couple of small kind of vassal-like telephone companies. They were permitted to interconnect. But there must be no interconnection from MCI, which is their bête noire, and no attachment of terminal equipment by customers, no foreign attachments. That was their absolute line. And so we told them that, well, they'd have to be able to give reasons, to a court. So they would give our reasons, and they had 3 reasons, or at least that's all I remember. The first was that, well, what if someone bought his own piece of terminal equipment, attached it to the network, and sent a powerful electric current through it? They could electrocute a lineman working on the network many miles away. So I don't know if that was a theoretical possibility, but we asked them, had there ever been an accident of that sort? They said no. Could always happen, always be a first time. As far as I know, there's still never been an accident of that, because the power, in fact, that goes through the phone line is very, very low. And so the big surge would probably just, blow out a fuse or something rather than cause this terrible death by electrocution. So that was a loser. The next argument that they pushed on us involved the Defense Department. Because the Defense Department had asked AT&T at its own expense, at AT&T's expense, to harden its microwave towers and its cables against a nuclear attack. Because we were going to win that nuclear war. We need good communications. And they'd also pressed AT&T, not 100%, but I know there was something about getting AT&T to build another underwater cable somewhere to, so the Soviet submarines would have more difficulty interrupting international communications. And so AT&T said, look, now MCI, they're not hardening their microwave tower. They've got these flimsy towers. When the bomb goes off, they're going to be all blown down. And they said this, would be unfair to allow them to compete with us because they don't bear this tremendous expense. And I thought it was kind of dubious. At first it seemed strange that a military measure should be financed by the telephone ratepayers rather than the taxpayers. But worse than that, of course, it was obviously a deal. It was kind of conspiracy with the Defense Department. That is, AT&T would finance a military defense measure, so it wouldn't be in the Defense Department's budget, and in exchange, Defense Department would support AT&T's monopoly. They would testify, that very, very important for AT&T. AT&T was a big part of the defense structure of the country, and it mustn't have its willingness to invest in these measures undermined because they're competing with someone who doesn't bear that expense. And one could have responded by saying, well, and I imagine that AT&T would have been content with the alternative of forcing MCI to harden its facilities because it couldn't have afforded to do that. So that we didn't think an impressive argument, the nuclear war argument. And their third argument, which was more emphatically pressed, was that you could not trust. It's sort of related to the electrocution argument, but it was you couldn't trust customers, whether business or individuals, to maintain their terminal equipment. So it was essential that they should only be permitted to lease it from Western Electric. And then Western Electric, or AT&T would replace it, when it wore out and so on. But that if you let ordinary people, attach their own equipment, you buy lousy equipment, wouldn't maintain it, it would break down. When it broke down, they would blame the telephone network. Say your network isn't working. Then AT&T would have to spend a lot of money, time, figuring out whether it was an equipment failure or a network failure, and they didn't want that. So I said to them, well, by that theory, shouldn't manufacturers of television sets refuse to sell the television set, but instead lease it, so that they won't have people, who keep it too long and don't maintain it, and so on and so forth? And they said, yeah, probably they should do that. Yes, probably should. Probably should. And then I said, well, but taking that a step further, wouldn't it make sense for clothing manufacturers to refuse to sell clothing, but instead to lease it? So, for example, suppose a shirt lasts 3 years before it frays or the buttons fall off. So you'd lease the shirt for 3 years. At the end of the 3 years, customer would return the shirt, you give them a fresh shirt. Well, then they knew they were being teased, and they said, no, that wouldn't make sense. No. But they couldn't actually articulate a reason why for the TV set or the telephone equipment, leasing is the way to go, but not for clothing. So I began to think after a while that looked like a long shot case, but on the other hand, they didn't seem actually to have any reasons that they could give for their position. At some point, I was asked to help organize an academic session for AT&T where leading economists would come and talk about the case with AT&T. AT&T was busy assembling a huge stable of economists on their payroll as potential witnesses. I think it's a general attitude of monopolization. They thought maybe they could monopolize the economics industry and leave no expert witnesses for the Justice Department. But they, so this was a session. They had a lot of good economists at Princeton. And George Stigler was one of them. And George, kind of out of the blue, said to them, well, of course you're going to lose the case. So the only question is, what kind of relief you might be able to negotiate. And I don't remember the reason he gave. It was something along the lines that you're so big, you're a monopoly, they're going to break you up, or they're going to do something. They're going to find that you violated Section 2 of the Sherman Act. And the AT&T people were really taken aback by this. You know, George, very distinguished economist and a conservative. So I think they began thinking, yes, they could lose it. And then they started getting, of course, negative signals from Judge Green. Well, my work for AT&T came to a somewhat abrupt end, I think around 1978. By this time, I was considered, I wasn't spending too much, I was considered kind of, I think they said, as part of their steering committee. So the steering committee had a meeting, and it was chaired by the general counsel, Mark Garlinghouse, who surprisingly, I read somewhere, had actually wanted to open up AT&T to competition, because that was not the impression he gave, but apparently behind the scenes he was losing faith in the monopoly. But at this meeting, I met probably a dozen people there, lawyers and so on. Garlinghouse passed out a one-sheet document, which was kind of the strategy of AT&T in the case. And it said that the strategy of AT&T was to delay the litigation, to stretch it out as long as possible. And Garlinghouse asked who agreed that this was, the correct strategy. And everyone said, everyone agreed except me. And I said, now the document, I didn't have a copy. For one thing, we were told to turn it back before we left. We weren't allowed to take copies with us. It was explosive. I don't remember, so I don't remember what, there was something in it beyond just dragging the heels. But I said, I didn't think we should do this because this is not ordinary private litigation. This is a Department of Justice lawsuit, and I think, we could be accused of obstruction of justice by this kind of delayed stuff. Well, that was not a popular suggestion. And George Saunders told me that Garlinghouse wanted to fire me on the spot, but George dissuaded him. Nevertheless, I wasn't, or very, very little, very little demand for my services after that, which was fine. So I had other things to do, and also I was worried about that obstruction of justice issue. I didn't want to be implicated. My last involvement with the case came in 1981, shortly before I became a judge. I was summoned to meet with Charles Brown, the CEO, and another person, probably the president, but I've forgotten. And the question he asked me, I didn't know, I'd lost touch with the case. He said that AT&T was thinking of making a deal in which it would divest itself of the local operating companies, and in exchange, it would be relieved from the 1956 consent decree, which had forbidden it to go into the computer business. And he asked me what I thought of that, and he said, and they had said for a long time, as far as I know is true, that their electronic switching was the most sophisticated computer technology in the world. So he said, we have this sophisticated computer technology, computer industry is booming, and we think we can, freed from this incubus of the 1956 decree, we can, be tremendously successful in computer industry, and so giving up the local companies would be a fair swap. So I said, I don't think that will work for you, because what I've noticed over the years is that AT&T does not have a marketing culture. And I remember from the discussions during the meetings how derisive the AT&T people were about customers wanting colored telephones. They thought that was ridiculous. Why would you want a colored telephone, a black telephone? I also remembered that I had heard of great dissatisfaction with AT&T by its business customers, because they felt if they had a need, went to AT&T and explained they needed a system for, connecting up offices or something, AT&T would say, fine, we've studied your needs, this is your system. And they said, well, we'd like to look at we'd like to see some alternatives, or we'd like to see, changed here, changed there. And AT&T said, no, we've studied your needs. This is your system. And that was the attitude. They did not respect their customers. And also, and we heard some this morning about the instabilities that you can get in a business where you can't predict your demand because, new products, multiple things. They wanted, of course, they did a lot of innovation, but they wanted everything introduced gradually, and they wanted uniform service, and they didn't want to have customers buffeting them with demands. So I said, and here was AT&T, a gigantic company, had 1 million employees during the 70s. So I said to Brown, I thought the culture of the company would not adapt to the computer industry, because even more than in business telephone services, it's not enough to have the very best equipment. The really important thing is, can you integrate the equipment with the customer's business? Can you explain it to them? Can you make it usable for them, and their needs are going to be idiosyncratic and so on? It didn't sound like AT&T. Now, whether Brown really thought that, I didn't make any impression, obviously, but whether Brown really thought that AT&T had a future in the computer industry, or whether he just thought he was going to lose because of Green, because Baxter's extreme hostility to AT&T, because they had spent 10 years trying to get legislation in Congress to protect their monopoly, and that had failed. So I don't know what his real motives were. But so anyway, that ended my involvement with AT&T. It was lucrative, it was fun. I learned a lot. What I learned is irrelevant to 2008, but best I can do. So anyway, those are my prepared remarks, and Chris had suggested you might have questions. We'll take some time. Thank you.
Anyone would like to ask any questions? So there's General Galbraith to do it. I think he's well enough handling crowds that he doesn't need much questions.
Yeah. Oh dear. Yes. Huh. Yes. Yeah, it's always an interesting question whether stonewalling is the best defense, or whether you want to compromise. I think AT&T probably made a mistake. I think if it had been more accommodating, it would have neutralized a lot of the threats, because it was a very powerful and popular company. Irritated people by its stubbornness, and by the sense that it was really frustrating innovation, not so much technical innovation as innovation in services and business innovation. Yes. Oh, I not really, but no, I see it. I see a tension with that because because Trinko, worries about companies being subjected to successive layers of the common carrier regulation and then antitrust, and that reflects some of the experience that was discussed this morning of a very complicated regulatory, legislative, judicial picture in the last since the decree. But it wasn't such a concern because of the fact that the FCC was really quite welcoming to the antitrust case, which it felt was supporting its own efforts to promote competition. Yes. Well, I think it may have been very significant that his superiors were recused, because it put Baxter on the level, on a cabinet level, in effect. That was important because the Defense Department opposed the litigation, faithful to its deal with AT&T. But I don't know. Baxter had been William French Smith, the Attorney General's choice, to be head of the antitrust division. I'm sure he respected him highly. Baxter, very smart, very forceful person, and extremely independent. They might have worried, that he might quit in anger if they overruled, because he felt very strongly about the case. Although interesting, by that time, AT&T might have been so far advanced in its thinking about the possible improvement of becoming a computer company that it wouldn't have made a great deal of difference. Yes, Tom? Yes. I don't think so, because I don't think Judge Green would have been a enthusiastic consumer of esoteric economic theories dreamed up by consultants to AT&T. I don't think so. I think the problem was that AT&T had defended its position for too long by reference to these implausible anecdotes, and it was hard for them to back away from that. I mean, there was their hushaphone position, which couldn't have been justified in terms of network externalities or what have you. So yeah, I don't think it would have. I don't think it would have worked. Yes. Tim? Yeah. Could you speak a little louder? Well, that the locals service was natural monopoly because you had the grid of lines to serve. But as far as long distance service was concerned, no, that was really an open question. There was, for example, competition in this international record. These international record carriers, there were several. So it wasn't out of the question that there could be competition. Now, an argument that wasn't pressed so hard. Well, I guess it must have been mentioned by the AT&T people. Maybe I just remember their silly arguments. But there was this, so the policy of AT&T was to subsidize local telephone service out of the revenues of the long distance service. So now there was a kind of I don't think the notion of network economies, I don't think that existed then. But they did have, but something like it. They would occasionally mention. They say, well, when you add someone to the network, you're increasing the value of the network to the existing users. There's one more person they might call, so they saw an advantage to that. But the real impression conveyed was that, as with the Defense Department, that they were subsidizing the local service out of the long distance for political reasons, that they wanted to build a huge popular base of supporters of the entire population would have very cheap basic service, because at that time long distance service was regarded as something of a luxury, and people were accustomed to paying very high rates for long distance, but they expected their local service to be very cheap. And so I just don't remember whether any efforts were made to convert this kind of base political argument into an economic argument about maximizing the size and value of the network. Yes. Glenn? Wait, I'm sorry, I can't hear you. Can you speak a little louder? I think yes, I think some because their relationship with the FCC that would be continuing. Okay, they'd lost a lot of battles in the 70s, but maybe in the 80s they'd do better. So I think they probably, apart from the the lure of the computer industry or a sense that they were doomed if the case went to final judgment and there was an appeal, they may have. If it hadn't been for those concerns, they might have felt we'd much rather deal with the FCC than have such irrevocable a consequence of a suit as being broken up. Because as they may have felt in the 80s, they do better with the FCC. Yeah. Mm-hmm. Mm-hmm. Yes. Yes. No, and the reason for that is that, if I remember correctly, which I may not, the case evolved very, very slowly. So by 1978, which was, I think, the end of my involvement, I don't think AT&T knew a great deal about what the government's theory was, because I don't remember discussions of what the government was going to argue. We would say, the government could say this, could do that, refusal to interconnect, arbitrary. They're an essential facility, and unless you permit interconnection, they won't be able to build themselves up into real competitors. But not much perception of what the government was likely to argue. And I have a feeling that at that period, AT&T hadn't disclosed much in the way of its litigating strategy. It was all still internal. Yes, Rod. Uh-huh. Huh. Yes. Yes. Yes, it's horrible. Yeah, yeah. Uh-huh, uh-huh. Yeah. 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 That's interesting. Yeah. Section 2. Yeah. Well, there was the notion of abuse of a monopoly's position, right? AT&T had a monopoly, and mhm. Yeah. Really? Uh-huh, uh-huh. Yeah. Mm-hmm. Mm-hmm. No, I didn't know that. Yeah, well, that wouldn't be unusual. No, there's nothing wrong. No, there's nothing wrong with that because so yes, suppose AT&T had prevented interconnection with competitors, and that with Western Electric had excluded other manufacturers of terminal equipment and so on. Suppose they'd done those bad things. Then the question, what you wanted to do about it wouldn't necessarily be just to enjoin those measures. You might think that divestiture would be feasible and would eliminate the incentives to engage in this conduct. So that would be appropriate. What would be odd, of course, is if the impression I'd gotten from Brown, but it doesn't mean anything, that he really saw this as an opportunity to get rid of a 1956 consent decree involving computers. I mean, that would be a real diversion from the issues in the lawsuit. Thank you.
We will reconvene in the conference room at 2:30.